Then we pass on to a very important, good afternoon to all of you. We pass on to a very important enactment called Hindu Law of Adoptions and Maintenance Act. Here, please remember at the outset, I would like to tell you that this act applies as far as the preamble is concerned only to Hindus and not to other communities. Here, why I am telling you that is, adoption is recognized only in Hindu law. As far as Muslim law is concerned, or Christian law is concerned, Parsi law is concerned, Sikh law is concerned, they do not apply. So, of course, Sikhs it applies because Sikhs are also classified as Hindus as laid down in Article 25 of the Constitution of India. Here, first and foremost is, before we go into the act in the proper perspective, it consists of two parts. One is what is called Jivanamsham, that is what is called maintenance, and Dattaku Tiskoda, that is what is called adoption. But the first part of it deals with adoptions. Before we go into the topic, we must know what the definitions as laid down in section 3. First and foremost, first definition that is given is custom and usage. That is having the continuously and uniformly observed for a long time and has the force of law in any local area, tribe, community, family or group. Here, custom, sometimes what happens is where it is observed continuously, notoriously, openly, uninterruptedly by a particular community, by a particular group, by a particular tribe, or by in any local area, it is called a custom, or it is also called a usage. Here, for example, here in Telangana, we have got some customary festivals like what is called Bonalu. Then we have got the what is called the Batkama Pandaga, and all these things. These things, by times immemorial, it is being followed. And among tribes, they have got their own festivals. In Andhra area, you have got the Gangama Jatra in the agency area. Then you have got the Nokalama Jatra in some of the areas in Srikakulam, etc. All this, and what is Rotila Pandaga, that is observed in Nellore, and some of the local festivals which are prevalent in a particular locality, in a particular area, in a particular group, in a particular community, in a particular tribe, it is called a custom. And custom is normally, sometimes it overrides the law also, provided it is followed for years together, openly, notoriously and continuously, it gains the sanction of law. And sometimes custom also overrides the law. One of the customs I could tell you is, there are various kinds of marriages which are prevalent in the various communities. For example, the Hindu law itself recognizes in the Marriage Act that you have got what is called Rakshasa marriage, that is elopement. Then another thing is called Gandharva marriage, another is called a natural marriage, another is what is called the exchange of rings and garlands, and so on and so forth. They are being followed from times immemorial. I also told you that among Lambadas, suppose a lady loses her husband, the husband's brother gets a right of marrying his sister-in-law. That is being followed from times immemorial. No one can destroy this custom, and these customs sometimes override the law, provided it is being followed by the community for times immemorial. Then maintenance. Please remember, maintenance can be said as Jivanamsam. Here, we require basics in life to keep our body and soul together. We require certain basic requirements. That is what is called food, clothing and shelter. Or in Hindi, they call it as roti, kapda or makan. We do not require the luxuries in life, but these three things are the basics in life. Because we have to keep our body and soul together, we require food. Because we have to live in a place where we can live safe, that is a shelter. And then what is called is to cover yourself. You cannot be like a nomad and go with go nude on the streets. So these are the three basic requirements which are required by every living human being, be it a man or be it a woman. So these things are called maintenance. Here I could give you a very classic example as to what happened in one of the northern states. What happened was a 77-year-old boy, I mean not boy, rather man, brought an action against his 99-year-old father claiming maintenance and also stating, "Sir, though I am younger to my father, I do not have sufficient means. I am begging on the street and my father is bound to maintain me." Here the courts in this case held the prime consideration is whether a person is able to maintain himself or not, irrespective of age or criteria. Then in that case, it is a duty of the parent, duty of the father to maintain the son. That is the reason why it is said that in India, the children are always parasites on their parents, unlike in America and all, where the child attains the age of majority, he or she is thrown on the streets to maintain themselves, to get themselves educated, and basic education is given to them by the parents. After that, the parents have no control over the children concerned. Then in one of the other cases, which happened in Maharashtra, a father who got his daughter educated and well placed in life, got her married to a doctor, spending huge monies for her education and the money, and ultimately was reduced to a pauper. Then the father filed a case against the daughter, claiming maintenance, stating that he is unable to maintain himself. The daughter contended, "Sir, the responsibility of my parents is only to educate me and only to get me married. And once I get married, I go to another family. I am not bound to maintain my father." And she also said, "If my father has not begotten a son, it is not my headache, it is his headache." But the court said, "Don't turn so ungrateful, where your father has spent his entire life earnings in educating you, getting you married, and getting you well placed in life. You shall not turn treacherous to your father." And the daughter was asked to maintain the father. So a maintenance especially has got a wider perspective and a wider significance. Why? Because we require three basics in life. That is what is called roti, kapda or makan, or what is called food, clothing and shelter. So maintenance is also included in this particular enactment. And now, of course, you've got a separate law also today to say maintenance of old aged parents. Senior Citizens Act is also there, where the RDO has been given quasi-judicial powers to decide these matters. Then we say, who's a minor? Minor is a person who has not completed the age of 18 years. A person who is below the age of 18 years is supposed to be an infant or is supposed to be a minor. Here, on the ground that such duty arises only if the child surrenders the protection and care of the parent. That is, only if the child surrenders the protection and care of the duty, or only if the child surrenders the protection and care of the parent. Here it is said a parent, I'm saying both mother and father cannot abdicate the duty of maintaining a minor child. The question is, unless they give up the child and say disown that child, the question is the parents are bound to maintain the child in a proper way. This was decided in AR 1986 AP 126. It was decided in AR 1986 AP 126. Then one more judgment is there, AR 1987 Orissa 251. Maintenance does not include legal expenses. Suppose legal expenses are involved and the minor has to spend money for that. The question is, parents are not bound to provide the legal expenses. That was what was held in AR 1987 Orissa 251. Here, among Hindus, we have got three types of children. One is called the Aurasa Putra, another is called the Dattaputra, and another is called the Dasiputra. As far as Aurasa Putra is concerned, Aurasa Putra is one who is naturally born to the parents, where the wife conceives and the child is brought up as that child. Dattaputra is, if there is no male child, a male child is adopted from another family and brought into the family and looked after as if he is a natural son. Then Dasiputra. Dasiputra means a child that is born to a Dasi or an exclusively kept concubine and the child is born. The Supreme Court has interpreted it by saying a Dasiputra is also entitled to the rights in respect of the property or the succession rights. But as far as Dattaputra is concerned, Dattaputra is always treated as a natural son or as an Aurasaputra. The question is, a Dattaputra enjoys a unique status. Though he severs his ties with with his natural parents and goes into the adopted family, though he acquires the surname of the adopted family, he does not lose his succession rights as far as his original family is concerned. So he is almost a Maharaja. He gets his property rights in respect of his adoptive parents as well as the natural parents also. So in Hindus, it is said a Dattaputra is also considered to be the Aurasaputra or the natural child of the parents. An adoption is, that is section 5 is, shall have any rights in favor of the adoptive family in favor of any person, that is which he could not have acquired except by reason of adoption, not destroy the rights of any person in the family of his original birth. So section 5 says, just because a person is given in adoption, he assumes the surname of the adoptive family, he does not lose the status of a legal heir as far as ancestral property is concerned in the natural parent's house. So he gets the rights not only regarding the adoptive family's property, but also regarding his natural parents' property, also provided it's ancestral property. That's what section 5 says. He can enjoy both the properties. Section 5 says, just because he has been given in adoption, just because he has acquired a surname which is different than the natural parents, it doesn't mean that he loses his rights regarding the ancestral properties of his natural parents. He gets a share there and also gets a share here. So he can enjoy both the shares accordingly. This is what section 5 says. Then regarding this, there is also embargo. What is the age within which you must take in adoption? You cannot take a person more than 15 years in adoption. That is, an adoption of a boy beyond the age of 15 years is void, is unenforceable at all. It is not an adoption at all. And that is why this was held in AR 2014, Karnataka 104. Even if the adoption deed is registered, even if there is a give and take by the natural parents and the adoptive parents, if the child is above the age of 15 years, then it is no adoption at all. The adoption is not valid. So to take in adoption or to give in adoption, the child should be below the age of 15 years, be it a male or be it a female. Then locus standi to challenge adoption. Locus standi, that is the capability to challenge the adoption, is AR 2016. Please note down AR 2016 Chhattisgarh 126. AR 2016 Chhattisgarh 126. The brother of the adoptive father, though not a party to the adoption, can challenge as if he has a right in ancestral property may get affected. Here, the brother of the adoptive father. Please remember, there the jealousy starts. Suppose the father has already got a son. Then another son is brought into the family. The son would be expecting a jackpot because he gets the entire share. But once the child comes, Aurasaputra, Dattaputra also becomes a natural son, the share of the natural son gets diminished. That is of the adoptive father. Whether he can challenge. Here the question is, it is said in one of the locus standi is AR 2016 Chhattisgarh, the brother of the adoptive father, though not a party to adoption, can challenge if his right in ancestral property may get affected. So, the brother, the naturally born child or the adoptive father can always challenge the adoption by saying that his rights will get affected as far as ancestral property is concerned because of the arrival of the adoptive son. He can challenge the adoption on various grounds which are available to him under the law. So the brother, that is, it is said, the brother of the adoptive father, though not a party to adoption, brother of the adoptive father, that is the father, that is the father's brother, can also challenge it by saying his rights will be affected as far as sharing of property is concerned in the ancestral property, though he can always challenge the adoption on some grounds. Then, sir, uh, correction in revenue records. All rituals were followed and contain particulars of adoption and biological parents. The procedure in revenue that is procedure in revenue records does not take away the rights of adoption, and directions to correct records were issued. So here the question is, once the child is taken in adoption and his name is not found in the revenue records, the court can always direct his name to be included in the revenue records because of the adoption. Here, what are the requisites of adoption? One is, person adopting has capacity to or right to take in adoption. Second is, giving adoption as right to do so. The person adopted is capable of being taken in adoption and subject to conditions. So one thing is, what are the requisites, sir? Give and take. Who has to give? Who is to take? The natural parents have to give, and the adoptive parents have to take. It's an offer and it's an acceptance. And what is the consideration? The consideration is the child is given in adoption. The child should be capable of being taken in adoption. The natural parents should be capable or competent to give in adoption. The adoptive parents should be capable of taking in adoption. And fourth one is, the question is, the person adopted is capable of being taken in adoption subject. So the question is, the child which is going to be taken in adoption should not be above 15 years. If it is above 15 years, that child cannot be taken in adoption. So again to repeat, what are the conditions, sir? The person giving adoption should have capability. The person taking adoption should be having capability. The person who is going to be taken in adoption should be capable of being taken in adoption, that is not above 15 years. These are the three basic requirements as far as adoption is concerned. Then what is the case law, sir? AR 1996 SC, please note down please, AR 1996 SC 591, where adoption took place by the ceremony of giving and taking, it is valid. So the question is, what is important is, there must be giving in adoption and taking in adoption. And normally among Hindus or especially Brahmins, there is what is called Datta Homam which is performed. That is where the child is given in adoption, taken in adoption, and then the natural parents give up that child and give it to the adoptive parents, and the adopted child goes into the family of the adoptive parents. So give and take has to be there. Competency of the adoptive parents, competency of the giving parents, and also the question is, the child which is given in adoption should be capable of being taken in adoption. That is, it should not be more than 15 years. Then next ruling is AR 2000 Odisha 158, where the adoptive mother denied adoption. It is onus is on the plaintiff to prove adoption. Suppose the plaintiffs, when the adoptive mother denied the adoption, the spouse of the adoptive father denies it, then who should prove, sir? The child which is taken in adoption has to prove valid adoption has taken place, valid home has taken place, valid customs have been followed, there has been giving and taking, and there are witnesses, and it has been reduced in the form of writing, and it has also been registered, and necessary changes have been made recognizing the adoption. The burden is on the person to prove adoption. Then AR 2004, Supreme Court, AR 2004, Supreme Court 1257. There is no prohibition in law. The ownership in a property cannot be gifted without the possession and right of enjoyment. In this case, gift was executed in 1945 and remained in force for 25 years, during which the donee had attained majority, and on becoming major did not repudiate it. Held, the donor cannot cancel the gift and execute a will in respect of the same property. Here it is said there is no prohibition in law. The ownership in a property cannot be gifted without its possession. Please remember, at the time when the gift is made, possession was not delivered, but the gift deed was executed. Then the gift was executed in 1945 and remained in force for 25 years, and the During that period, they only attained majority. The question is, gift cannot be resumed, gift cannot be repudiated, though possession was not delivered. Then validity of adoption where child above 15 years. AR 2017 Madras 37. The age of the adoptive son was 20 years, that is beyond 15 years. No custom or usage, and he was the only son of his parents. Adoption not valid. Please remember, sir, అంటారు వాడు పిండం పెడతాడో లేదో వాడు ఇంగ్లం పడతాడో లేదో కానీ అబ్బాయి అనేది ఒకటి ఉండాలని. ఇట్స్ ఎ మిస్నోమర్, సార్. సమ్టైమ్స్ ద డాటర్స్ ఆర్ better than boys, because at least daughters, if something happens to you, they are the first people to come in running. The son is only after your property. Son is only to see that you die as early as possible so that he gets his property. But here the question is, the adoptive son was about 20 years, that is beyond 15 years. So to say that even after 15 years you can take in adoption, if there is any custom, if there is any usage in the community to take in adoption of a person even beyond 15 years, the question that can be enforced. But if there is no custom or usage which can be proved or established, the adoption will not be valid. Then, sir, AR 2011 Supreme Court 644. A person having a wife cannot adopt without her consent. The court cannot presume that simply because the wife was present at the time of ceremonies, it cannot be held that she gave her consent. Please remember, for everything in life, you require what is called Mia Bibi Razi to kya karega kazi. The question is, for everything you require the consent of your wife. There are some wives, there are some ladies who just dissent always, even for good things and bad things they dissent. But in this particular case, the wife was present in all the ceremonies, but she did not give her consent to take a child in adoption. The question that arose before the Supreme Court was whether it was a valid adoption or not, because this lady was present. Whether her consent can be implied. The courts negated and said that simply because she is present at the time of ceremonies, it cannot be said that she has consented for adoption. So the question is, for an adoption to be valid and enforceable, there should be consent of both husband and wife. Without the wife's consent, an adoption cannot take place. These are the various case laws, sir. Now we go to section 8. Capacity of a female Hindu to take in adoption. It is permissible for a female Hindu who is of sound mind and above 18 years to take adoption, provided that she is not married or a widow or a divorcee, or after marriage her husband renounced the world. It is permissible for a female Hindu who is in sound mind and above 18 years to take adoption. So suppose it is said even a female Hindu also can take adoption, take in some person as adoption, provided that she is above the age of 18 years and she was of sound mind, and she is not a widow, she is not a divorcee, and after marriage her husband has renounced the world. This was as per Act 30 of 2010 or AAR 2008 SC 1056. So we have finished up to section 8. The other sections we shall discuss it in the next class. We have got in this, it's a very small enactment. It comprises of only 28 sections. Or we'll discuss one more section and stop. Persons capable of giving in adoption. Who can give adoption? Naturally, sir, you can agree with me. The person who can give adoption is the natural parents, the father and mother. Then, second one is father and mother equal rights. Either the father can give in adoption or mother can give in adoption. But the consent of each other has to be taken before the child is given in adoption. Then it cannot be done if one of them has renounced the world or ceased to be a Hindu and declared as a person of unsound mind. Then it can be given by the father or mother. Then no person except, then second one is they have got father and mother have got equal rights. And third one is it cannot be given in adoption if the person concerned has become a sannyasi, or has renounced the world, or has become of unsound mind, where both have renounced the world or abandoned the child or of unsound mind, where the parentage of the child is not known, the guardian may give the child in adoption. The question is, suppose let us say one is naturally, who can give an adoption, sir? Father and mother. Second one is father and mother have got equal rights. Third one is if one of them has renounced the word or has become unsound mind, incapable of giving adoption. Fourth one is what both of them have turned unsound, or both of them have become sannyasini, or what is called jogini, or a sannyasi. They cannot give in adoption, but the guardian of the minor can definitely give in adoption. Then what is meant by abandonment? అంటే గాలి గోదిలేస్తారని చూడండి, అదే అబెండన్మెంట్ అంటారు. AR 2015 Allahabad 33. Mother of the child was deaf and dumb and no information of the father. Both parents living in a protection home. Mother was incapable of taking care of her child due to her disabilities. She deserted her child. This amounts to abandonment. Before guardian is granted permission, the welfare of the child, understanding of the child, and no rewards is given. Welfare child cannot be kept in a state woman home beyond the age of 7 years, and adoption is necessary. As laid down in AR 2015 Allahabad 33. Here the mother of the child unfortunately was deaf and dumb. She cannot communicate, she cannot hear, and her mental faculties completely failed, and she could not take care of the child, and they had no information as to the whereabouts of the father, and the mother was living in the woman's care. Then because of her disability, she abandoned the child, deserted her child, and this amounts to what is called gali godilero. That is what is called abandonment. Then here in this case, permission was granted to the guardian to give the child in adoption, but the guardian should not make money over giving the minor in adoption. Then adoption is quite valid. Then the question is, welfare of the child is involved. That is 2015 Allahabad 33. Child cannot be kept, please remember, in the woman's home. A child cannot be kept beyond 7 years, and that is the reason adoption was necessary and permission was granted to give the child in adoption by the guardian. 8 వరకు అయిపోయింది.